Thank you.
Are those henna or are they permanent?
No, they're real.
Oh, they're real. Oh, cool. You rebel, you. It's all that Woodstock.
It's all that sunny view.
Wow. I bet it was.
See, look what you created.
Did you go to Sunnyview? You did? Oh, wow. That's where I met her. Oh, okay. I was a counselor there. Oh, wow. She was running the place.
No, I was answering the
How long
phone
is the delay in Beltrans?
and going to get the counselors when someone was giving me a call. It's your friend calling.
Good afternoon, everyone. We're just waiting for a few minutes because we've had a delay with the Wheel-Trans. So we'll start in about 10 minutes. Good afternoon, everyone. I am José Bouchard from the Law Society of Upper Canada. I just want you to note that there are 2 sign language interpreters right there located to my right. And before we begin, I should probably let everybody know where accessible washrooms are. There is one washroom through that door to the right, and it is in the hallway, you will see it. Or there is also another washroom if you take the elevators down to M, and when the doors open, you will see the washroom. I am very pleased to welcome all of you to today's event to promote National Access Awareness Week. This event is one of a series of events that the Law Society hosts here to encourage the exchange of information, ideas and action on legal issues relating to the rights and needs of equality-seeking groups. I would like to take this opportunity to recognize and give thanks to our official partner for this year and for a number of years in organizing this event, ARCH, the Legal Resource Center for Persons with Disabilities. ARCH has been a very active and wonderful partner to work with. ARCH is a specialty legal aid clinic dedicated to defending and advancing equality rights for persons with disabilities. And the board, volunteers, and staff of ARCH, to them I would like to thank for their assistance, partnership, support over the years, and helping us develop initiatives and programs in the area of disability. I would like to ask Phyllis Gordon, Executive Director of ARCH, to say a few words.
Thank you, José, and on behalf of ARCH, welcome, and we're thrilled to see so many people here. It's really inspiring. Before the panel begins, I wanted to tell you all about one particular ARCH project which is related to today's event. We have undertaken a project of developing a series of fact sheets about abuse of people with disabilities, and you'll find the first 5 of the fact sheets in the binder. Others are still in development, and we'll certainly let you all know when they're available. It's our intention to publish the full series of fact sheets in several formats in the next while, and all of the fact sheets will be on our website. This project grew out of the need to revise a booklet on abuse that ARCH authored in 1990. Over the years, we've continued to receive requests for this booklet, but it's out of date, and so we've taken the initiative to update it. The fact sheets are the updating. We've been most fortunate in the project to have received the support of the Victim Services Secretariat of the Ministry of the Attorney General. But apart from the Attorney General, there have been several highly committed individuals who agreed to join ARCH in the work and have generously participated and given their time on our advisory committee. While the final content is our responsibility, we are really appreciative of the knowledge, advice, and insight of the following people who have worked on the fact sheets, and I'd like to list them, and I think I see some of them in the audience. Harry Beattie is here, disability lawyer and consultant. Harry, where are you? There you go. Sandy Bell is coming soon. I saw her a while ago. Oh, there she is. She's here, great. Okay, Sandy Bell is an equity consultant and mediator and on the Arch Board. Nev Crescente is the center of the panel. She's with the Attorney General and the Ontario Victim Services Secretariat. Lana Fredo, who is on our board and is also the Executive Director of Sound Time Support Services. Jennifer Gibson, another Crown attorney. Tim Kinney is here from the Ontario Federation for Cerebral Palsy. Where are you, Tim? Anyhow, there you go. Tim's put in a lot of time. Fran Odette, who's on the panel, has put in a considerable amount of time. Marianne Park is over there in the far corner and has waved her hand. She's also facilitator and instructor and an advocate on Dawn Ontario board. And Maria Teresa Paul from ERDCO, the Ethno-Racial People Disability Coalition of Ontario, I don't think was able to come today, but sent her regrets and her greetings to you. And Kara Wilkie, who's an articling student at Arch. I really want to thank these people because they've provided us with some insight and some grounding, and as we move forward into the next series, which will focus not so much on the criminal law, but on other legal contexts, hope we can call upon them again. There's another person I'd like to just thank today because two people who have done a lot to bring us together, and that's Helen Henderson of the Toronto Star. Helen, is over in the corner near the door, and Helen has raised the issue of abuse of people with disabilities in a recent series, and as well, some of the people that she has spoken with and who have bravely decided to go public are here, and we really appreciate their contribution, particularly that of Ann Abbott, who's here today. Thank you for coming and in such numbers. Clearly, this is an issue we will be working on for quite a while. And together, we hope with some of you, with such a degree of community interest, we're going to move ahead on this really critical issue. There's one more detail, and that's that we have evaluation forms, and our funders really like us to ask you for evaluation forms and input about what you thought and what future events, whatever you can do. So they're in the binders, and we'll talk about them later on. Thanks very much. Give the mic to somebody. What am I supposed to do? Not very good with these. You all right? Yeah. Okay.
Thank you, Phyllis. I will be moderating the panel, which means that I will not be doing too much talking, although I will be repeating the questions so that everybody can hear us. Before we start with the introductions of our distinguished panelists, I've been asked to ask the audience to identify communities of interest that you are from based on the registration forms that we have. We discussed this idea because we wanted at first to have everybody introduce themselves, but because of the wonderful turnout tonight, I think that would be counterproductive. It would take too long. So, of course, you do not have to identify yourself if you do not want to, but we just want to see, to get a sense of who is in the audience. So I'd like you to identify yourself if you come from an agency that provides services to persons with disabilities. So I would say we have approximately 30 individuals from that group here. I am doing a quick count, as you can tell. Could you tell us if you provide assistance to an individual with a disability? So we have approximately 10 individuals here. Do you practice law? So we have approximately 5 individuals who practice law in the room. Are you a Crown attorney? Yes, we have 1 or 2 Crown attorneys in the room. Are you a member of the police? It does not appear that we have a member of the police. I'm not sure if I saw a hand. Do you work as a non-lawyer advocate for persons with disabilities? So we have a fair amount, approximately 10 to 15 individuals who identify in that category. Are you a member of the media? So we have quite a good number of individuals from the media, approximately between 5 and 10 individuals. Do you do policy or research work in this area? So we have approximately 5 to 10 individuals who identify in that category. Did I leave any significant groups out? All right, thank you so much. That is very helpful for those who will ask questions and participate in the discussion. Now it is my pleasure to introduce the speakers for today's event. Our first speaker, and I will introduce them in the order that they will be speaking. So our first speaker is Fran Odette, and she is the third person to my left. Fran Odette is the project coordinator of the Women with Disabilities Deaf Women's Program at Education Wife Assault. She has been working in the area of violence prevention and disability for approximately 15 years, providing both direct service and advocacy-related support to women living with disabilities who are fleeing violence. Ms. Odette is also an educator trainer in the area of gender violence and disability. And she also does work with service providers and women living with disabilities on issues related to sexuality, healthy relationships, body image, and access to services. Ms. Odette recently co-authored a book with Corey Silverberg and Miriam Kaufman entitled The Ultimate Guide to Sex and Disability for All of Us Who Live with Disabilities, Chronic Pain, and Illness. Our second speaker is sitting to my left, and it is Lana Kersner, who is a staff lawyer at Arch. She has worked in the community legal clinic system since 1998, both at Arch and at the Advocacy Center for the Elderly. She has been involved in many of Arch's activities, including law reform, legal writing, public legal education, and summary advice and referral. Her areas of interest include laws as they relate to persons with disabilities in the context of abuse, departmental services, consent and capacity, attendant services, and home care. Ms. Kersner also worked in private practice, specializing in wills, estates, and health law. Our third speaker will be Gwen Reed, who is sitting at the end of the table. And Gwen works with Education Wife Assault and Sexability as a facilitator, a trainer. Ms. Reed also works at the 519 Church Street Community Center in the community living programs part-time with people living with intellectual and multiple disabilities. And our final speaker will be Navina Crisante, who is a lawyer and is currently working with the Ontario Victim Services Secretariat of the Ministry of the Attorney General. Ms. Crisante worked in private practice for over 10 years with a focus on criminal trial and appellate work and women's rights advocacy. In 1998 and 99, Ms. Crisante was supervisor of Staff Duty Council, and between 2000 and 2005, she was an assistant Crown Attorney. So I welcome our panelists, and I think we will begin the discussion now.
Can people hear me? Yes, great. Okay. It's a pleasure to be here today and to see so many of you here tonight. And I want to say thank you for this opportunity. Today we're going to be talking about abuse against people with disabilities, and while I'm going to be talking more specifically about issues for women living with disabilities, and I'm going to be putting on a more gendered lens on the experiences of violence, I do want to emphasize and can't emphasize enough that men living with disabilities experience violence, and men living with disabilities experience higher rates of abuse than men living without disabilities. We don't really know what the stats are currently, only because there are not many comprehensive studies out there speaking to men's experiences. In the more broader context. We are hearing more specifically about men's experiences who may have particular types of disabilities, but we don't really know across the board what the stats are. But we can assume that if women living with disabilities are abused 2 to 5 times greater than women living without disabilities, we can also make similar assumptions for men as well. I want to be really clear that I am going to be talking about women with disabilities, and I'm also going to be giving you a little bit of context around the history of the systems that have come into place that have created our vulnerability. Researcher Monica Chappelle suggests that while it is common knowledge that violence against women is widespread and pervasive, confirmed as such by many research studies, surveys, and statistical analysis, when we look at the issues of violence against people with disabilities and bring it gendered lens, we see that there has been very little similar research taken place concerning women with disabilities. As noted by human rights lawyer Yvonne Peters, reported as the silent epidemic. She says the abuse and exploitation of women with disabilities, and I would say quite confidently of people with disabilities, has been tagged the silent epidemic. Silent because it is not often talked about and has not been identified as a serious or significant issue. We know that that's not true by the number of you that are here today. Epidemic because the more the surface is scratched, the more women, and I'm going to broaden that, the more that men and women are coming forward with personal testimonies of abuse and humiliation. This relates largely to the invisibility of disability in the stats and research initiatives that are related to the experience of violence. This invisibility of our lives relates to the long history in which disability has been perceived, particularly within Western culture and elsewhere, as something that is strange and so very different because society keeps us hidden away. We have been segregated in special schools and in special programs that are actually quite designed to pacify many of those not living with disabilities into thinking that they've done enough. Disability as a phenomenon makes people confront their fear of suffering, a fear which centers on an obsession which is based on the conventions of what is considered whole and how a body should look and how a body should function. And this attitude underlies the horror instilled by physical difference. In order to deal with the phenomenon of difference in disability, we see that in the earlier part of our history, back as far as the 19th century, which really wasn't that long ago, it marks the birth of the institution, a safe, caring place where people with disabilities could be taken care of and forgotten about. Sociologist Finkelstein sees this era as a time when, quote, cripples disappeared and disability was created. Disability becomes socially constructed and used as a tool by which to justify the need to keep us separate. Keeping us isolated and separate gives greater weight to seeing those of us living with disabilities as less than and as having a condition that is essential to an increased sense of vulnerability. Disability becomes stigmatized and is a way of victim blaming, and it becomes a thing of shame. Within the institutional model of quote-unquote care, there was a belief that charity was not given unconditionally. It was suggested that pity and charity oftentimes creates resentment, especially if the sufferer does not get well. Resentment leads to brutalization. Thus arises another era that justified the need to keep those of us considered defective segregated. Institutions were perfect breeding grounds, oftentimes, for experimentation and abuse. The institution provided an ideal opportunity for doctors who were quote-unquote concerned about our care to gain access to our bodies and to our minds. It's suggested that during this era, that doctors and other professionals of medicine colonized disability, much like a country has been colonized, and turned people with disabilities into material for research and exploitation. Throughout the years, the perception of disability is seen as a personal problem or a personal tragedy, as a way of absolving the larger society from having to take responsibility. If disability is seen as inherently bad, then there's not much that society can really do about it but offer charity and pity. When we look back, history reveals itself to the stark reality that patterns of abuse are common, ranging from the mistreatment to dehumanization of many groups, demonstrated in social policies directed towards people of color, First Nations and Aboriginal communities, women, the gay community, children, people living with disabilities, and the Jewish community. Dehumanization and brutalization are key factors, all of which have contributed to and been the basis for a very horrific time in our history. By reducing those of us who are identified as human, even though some of us might not see us as such, to subhuman states, we are not obligated to treat them with the same rules of civilized conduct that we expect of and accord other humans. Systemic justices had an early beginning for many of us living on the margins and whom are not considered to be part of the mainstream. When we look at the situation for women living with disabilities, we are witness to the fact that historically, women with disabilities have had to struggle against widespread discrimination within a variety of systems, including the criminal justice system. There are many levels to the criminal justice system, and each one has its own tests that oftentimes discourages women with disabilities from striving to attain justice. We know that cases involving women with disabilities, and we also know cases involving men with disabilities, that often require extra time, effort, and accommodation in order for their needs to be met. Budget restrictions are often used as the rationale when cases that are considered to be more difficult are seen as no-wins, while those cases that are considered easier to win are more readily dealt with. Barriers such as the backlogs in courts, coupled with discrimination and the lack of understanding about disability and the lived experience of disability, creates for some formidable barriers. A researcher by the name of Hard reported that of 64% of women labeled with an intellectual disability who were interviewed in her research, who told someone about the abuse that they were experiencing, compared to 40% of the men living with an intellectual disability, slightly over half of the women were not believed, while all of the men were. Of the women who disclosed and were believed, 75% indicated that the abuse stopped. In all of the cases involving men, the abuse did stop. In the cases of women who were not believed, 55% continued to experience abuse. Dick Sobsey, who is a Canadian researcher, found that only 23% of the people that he spoke to of disclosed cases resulted in charges being filed, and only 6% of those cases led to convictions. The reason for not pressing charges was that the victim was not a credible witness. While women living with disabilities present some unique challenges to the legal system, we need to outline what some of those challenges might be. For example, it might be considered a challenge for a judge to hear the testimony of a woman when the courthouse is not accessible or minimally accessible. It may be a challenge for a judge to determine the competency of a woman living with a label of intellectual disability. How does a judge determine whether an interpreter is credible? How will the judge determine a damage award that accurately reflects the poverty and accessibility needs of an individual living with a disability? How does a woman who cannot communicate her non-compliance around sexual acts communicate that in court? Which accessible services are available, and what does access really mean? We need to work in partnership, we being all of us, need to work in partnership with the systems that are in place to help answer these and other questions so that the system can become more accessible and support equitable access to justice. Kathy McPherson, who wrote the Responding to Abuse that was put out by Arch in 1990, which was incredibly well received, and as Phyllis had mentioned, was no longer in print. She is quoted as saying, "Victims with disabilities should be supported and encouraged to use the justice system." This was back in 1990. I don't think much has changed. Using the law can help to empower people with disabilities who have been victimized and give them the opportunity to feel validated and vindicated. It can lead to the punishment of abusers and may deter them from abusing others. It indicates to abusers and to the community that we mean business, and helps to educate courts and the public that the abuse of people with disabilities is a problem that needs to be taken seriously. Until very recently, people with disabilities were left out of the justice system. For women with disabilities, many of us continue to go forward with our cases, but oftentimes we're just given lip service, while the real issues don't get discussed. There is still very little research done on the impact of violence for people with disabilities when compared to looking at the experience of violence for people who don't live with disabilities. The evidence is clear that there is an epidemic of violence in our lives, and the challenge is changing that. In order to change, more information is needed. We need to do more work around anti-violence. We need to put more money in prevention as well as treatment. And we need to have partnerships with people with disabilities to seek our input into services. It's hoped that we have learned from the atrocities of long ago and not so long ago, so that we can move forward to a more just view of the world, hoping never to repeat history. However, some themes or ideologies are stronger and more prevalent, and it is our duty after today to continue to battle those injustices. The challenges before us is to look at our own attitudes, which have been shaped by history, a history that has valued some lives over others, remembering that people with disabilities have also been part of that history and have also had their own self-esteem influenced by that history. Given the vulnerability of people with disabilities in this society, and I don't mean vulnerability because we live with disability, some of us are, but really it is the systems that are in place that make us vulnerable. And we need to continue our efforts to look at the strategies that are going to work and to look at the impact of those strategies over the longer term. Not for those of us living with disabilities who are survivors, but for all of us. Thank you.
Lana Kirzner.
I wonder if this mic is on. Can everyone hear me? Yeah? Okay. I'm going to be talking about the legal context of abuse of persons with disabilities. And there are two questions that people ask us at Arch regarding abuse that come up over and over again. And they are, how is abuse defined in law? And what is the legal remedy for abuse? People usually expect that there is a straightforward definition of abuse and that there is one single legal remedy, and all they need to know is find out what it is and then they can take action. In fact, there is no specific definition of abuse in law. There is also no single law to resort to in situations of abuse. While abuse is always wrong and always inappropriate, the behavior may not always be a violation of law. On the other hand, a single event of abuse can be the subject of many potential legal remedies. A number of factors come into play in explaining the prevalence of abuse that Fran just described. And one of these is the lack of knowledge amongst the players in the system. So persons with disabilities often do not know where to turn and what laws exist to protect their rights. Further, persons with disabilities often do not have the resources to pursue their legal rights. Similarly, service providers often aren't familiar with what laws govern their duties with respect to abuse, or how to assist their clients to access the legal system. Legal professionals as well are often unsure about the various legal avenues that are available in the context of abuse of persons with disabilities. Another factor which plays a role in the prevalence of abuse is the general misconceptions in society about the way in which abuse is experienced by persons with disabilities. There's a typical image conjured when one hears the word abuse. The person was abused the person is often thought of to have experienced abuse in one of a few typical ways, for example, having been hit or having been forced to engage in sex without their consent. Often people think that there is only one response, which is to immediately call the police and engage the criminal process. The picture of abuse for persons with disabilities is often much less obvious or understood. Consider, for example, a caregiver who leaves a person with a disability either on the toilet or in bed in their own feces for 3 hours when they know the person cannot independently, because of their disability, clean themselves or get off the toilet. Consider another example. Friends who live in a group home are socializing over a cup of coffee. The staff member of the group home becomes frustrated by what he describes as their noise and tells them that they are worthless because they have disabilities and they have to stop talking immediately. These two are examples of abuse. However, because they are not recognized as such, they are not taken seriously or addressed as abuse by the persons who experience abuse, by the abusers, and by the legal system. So there are many legal avenues which exist to address abuse, and they differ significantly from each other. And I'm not going to talk about each legal avenue in detail, and you'll find many of them discussed in the fact sheets. But what I'd like to do is to provide some examples for you to give a framework of thinking and of understanding the broad legal context to think about abuse in persons with disabilities. As we've said, most people are familiar with the criminal route for dealing with abuse, where the person who experiences abuse calls the police with the potential result that the abuser will be charged with a criminal offense. And Navina is going to be talking about that shortly, and she'll be explaining that process in more detail. There's also the Criminal Injuries Compensation Board, which is a process by which a victim of a crime of violence can apply for monetary compensation. To do this, the person need not necessarily, the abuser need not necessarily have been charged or found guilty of a crime. The person who's experienced abuse can sue the abuser in a civil litigation action, and this could be an action on the basis of assault, but it might also be an action on the basis of breach of contract. The person might also complain about discrimination or harassment through a complaint to a Human Rights Commission, either the Ontario Human Rights Commission or the Canadian Human Rights Commission. If the person has experienced an abuse at the hands of a health professional, they can complain about the abuse to their regulatory body, which might be the College of Physicians and Surgeons of Ontario, and that's just one of many regulatory bodies of health professionals. There are also specific complaints and appeals processes in specific statutes which govern certain situations, such as people who experience abuse through the receipt of home care services through community care access centers, and there is a complaint process mandated by the Long-Term Care Act. And there is also a potential to complain to government ministries that fund programs, for example, supportive housing provided to people with physical disabilities or people who experience the mental health system. If they experience abuse, they can complain to the Ministry of Health and Long-Term Care. If people experience abuse in group homes, they can complain to the Ministry of Community and Social Services. So this list is really not at all a complete list, and it's just an example of some of the potential remedies that one might seek. So to illustrate how these all play out, I'm going to provide a scenario. Joan is a wheelchair user. She relies on attendants to transfer her in and out of bed. She receives attendant services through a program funded by the Ministry of Health and Long-Term Care. Her attendant, Sally, is an employee not of the ministry, but of a private agency which receives funding from the ministry. One day, Sally becomes impatient and angry with Joan because she can't understand Joan's communication. In transferring Joan out of bed, she does so roughly and without paying attention to the proper method for doing the transfer. During the transfer, Joan's legs bang against the bed harshly, such that she sustains a broken ankle and many severe bruises. There are many legal approaches that she could consider in pursuing this event. Her most immediate action might be to call the police. However, she could launch a complaint with the agency that provides the services. She could launch a civil suit on the basis of assault or potentially breach of contract, depending on whether she signed a contract and what it says. She could seek compensation through the Criminal Injuries Compensation Board, or she could consider taking legal action against, in this case, the Ministry of Health and Long-Term Care. So the big question in many of your minds is probably, how does one know what avenue to pursue in the face of all of these options? The impact on the person's life who's experienced abuse cannot be underestimated and must be strongly considered. The vulnerability of the person who has experienced the abuse is an essential consideration. Persons with disabilities often rely on others to assist them with their most personal and essential needs, such as bathing, eating, or taking medicines. If one of the people on whom they rely also is the abuser, any action they take may sacrifice the assistance they receive, or make the abuse worse, because there is a potential that the abuser will get angry and take steps to retaliate. Of equal importance is the fact that most legal avenues involve serious intrusion into the privacy of the person who has experienced the abuse. The person may have to testify in court and divulge very personal details about their life and the abuse situation to a host of strangers. Even when there is no oral hearing, it is equally invasive to have to provide personal details in the written complaint forms that are often necessary. Additionally, legal processes often take many years to resolve, although some of them are shorter than others. This can have a profound impact on the person who has experienced abuse, as they have to relive the experience as they prepare the case and proceed through each step. It makes it very hard for them to find closure. There are other legal considerations that are also important in deciding which avenues to pursue, and these include different time limits. Most legal avenues involve what are called limitation periods, which are time limits within which a person must take action. And the time limits differ depending on the process. The evidence and legal outcomes of some processes often impact on others. So, for example, the evidence that's adduced at a criminal trial and the result of that criminal trial may have an impact on a civil suit or a criminal injuries compensation case. Financial considerations, too, are important. Some avenues can be pursued without hiring a lawyer, such as complaining within an agency, while others, such as civil lawsuits, are more complicated and often require legal representation. Another issue is what remedy the person who's experienced abuse is seeking. Sometimes they want compensation, and in other cases, it is of utmost importance to them that the person who's abused them be punished. There are also various levels of control that the person who's experienced abuse may have over the legal process. With a civil suit, the person who's experienced abuse can decide how to proceed and whether they wish to stop the process at any time. While in the criminal process, the person who's experienced abuse often loses control, as it is usually the Crown's decision as to whether to proceed. There are also, in some circumstances, mandatory reporting requirements of abuse that are irrespective of what the person who's experienced the abuse wishes. However, there are very few of these, and much fewer than most people think of. So what is my ultimate message today? My ultimate message is that in most cases, it is the person who's experienced abuse themselves who has the right to choose what action they want to take and what legal avenues they want to pursue, if any. There are many different legal options that exist, and it is important to consider the legal components and implications on people's lives of all options before making a decision as to whether and which ones they wish to pursue. Finally, it is not an easy choice in view of the complexity of the interaction between the laws and the potential life-altering effects of taking action. And I'm sure that with the other two speakers, those issues will be more fully explained. Thank you.
Now we will move on to Gwen Reed.
Thank you. I have a bit of a cold, so if you need me to repeat something, just let me know. Good afternoon. The information that I will be sharing comes from both my experiences as a victim and a witness for the Crown, and my experience as a woman living with a disability who self-advocates and advocates for others. The rape itself occurred in the summer of 1995. I did not tell anyone until the November after. Once I gave my statement and decided to charge the accused, the process began. In the following summer of 1996, my first preliminary hearing was scheduled. I distinctly remember the day when I received my subpoena to attend the trial. At this point, I had already completed a support group for women survivors of abuse. I was also appointed a personal counselor who dealt with abuse cases. The majority of my personal healing was accomplished at this point. I went into the trial knowing that the accused could possibly walk free. My uncle, who is a lawyer, warned me that what actually came out in the trial and the event that specifically took place could be two totally different statements. He also reminded me that the defense lawyer's job was to get the accused off by bringing in whatever information that would discredit my testimony. He warned me that my past depressions would be brought out as a reason not to credit my testimony as a witness for the Crown. Another point to consider is that the accused was partially paralyzed, and due to my disability, I have issues with transferring and mobility. Now that I have set the stage for my experience, it will be clearer as to the issues that were barriers to me within the court system, and as a woman survivor of abuse who happens to have a physical disability. Firstly, the witness box was not wheelchair accessible. This posed two problems in the case of my trial. My counselor, who was with me as a support, had to physically help me transfer into the witness box, as the step was quite high and not easy to manage. Fortunately, in my case, I was able to bear weight and to do a pivot transfer with some minimal assistance. However, after halfway through my testimony, I remember taking a break and almost blacking out due to stress. This was both demeaning and dangerous. In my opinion, I think it also impacted the way the jury members viewed my disability. The accused also required assistance to transfer to and from the witness box. The second consideration was that the jury box was also not accessible. While viewing the jurors entering their seats, it was clear to me that none of them had any apparent visible physical challenges. Personally, I think that this was not inclusive, as it would have not allowed someone with a physical challenge to be on that jury. I am not saying that someone on the jury did not have a hidden disability. However, there was no obvious physical challenge to anyone on the jury during this trial. I also found that due to the busyness of the Crown's schedule, it was hard to meet with him even one time before my trial. With having to rely on Wheel-Trans for my transportation, our schedules didn't always coincide. I would have liked to spend more time going over the facts with him and in preparing for my case, as it was both emotionally draining and physically exhausting. I was offered the services of a counselor for the Victim Witness Assistance Program. However, my personal counselor at the time also appeared in many court cases with previous clients, and I was confident that she would provide me with sufficient support. I would like to talk about people's perceptions of a woman or a man with a disability. In my work at Education Wife Assault, we often try to educate people regarding the falseness of some of the stereotypes regarding people living with disabilities. One specific stereotype that comes to mind is that people with disabilities are asexual. We are often seen as hypersexual or on the opposite end of the spectrum. These two particular stereotypes could be a barrier within a date rape case of this type, where both the victim and the accused are people with disabilities. It could be assumed that the victim was looking for a sexual experience because he or she doesn't get sex very often. It could also be assumed that, well, how could a guy with a physical disability who needs help to transfer into the witness box possibly rape a woman who is someone using an electric wheelchair? I am surely not saying that everyone who is, quote, normal would make these assumptions, but many people have believed these stereotypes. I also work with Sexability, which is funded through Planned Parenthood of Toronto and is located at the Ann Johnson Health Station. We work on educating youth and adults with physical disabilities in the areas of healthy and unhealthy relationships, self-esteem, and the sexual reproductive system. We also work with their service providers, such as counselors, nurses, community workers, in helping them to provide their clients with the necessary assistance, educating them on issues of access in terms of the barriers that their clients face. With the combination of my experience as a facilitator working for both agencies, as well as the work that I do at the 519 Church Street Community Center for adults living with intellectual and multiple disabilities, I see many of the social challenges that they are dealing with. People with intellectual and psychiatric disabilities are often seen as hypersexual. The key points to ponder are the following. First, the physical access to the courtroom, the witness box, and the jury box, as well as washrooms. potential biases of people with disabilities regarding them as sexual beings as opposed to asexual or hypersexual, court assistance for written and or verbal testimonies. For example, if someone has a learning disability where he or she needs their written testimony for them to be transcribed, or where someone is blind or visually impaired and needs alternate formats such as Braille or large print, as well as a person to do the transcription. I would also like to mention that scheduled breaks for washroom or guide dog relieving, dietary needs, etc., are very important. In my trial, for example, I sat in the witness box for nearly 2 hours without a break and was literally ready to pass out. That was before I was asked if I wanted to take a break. Alternate ways of communicating with court officials, such as email or teleconferencing, to provide more opportunity for prep time, even with alternate formats of transportation, such as Wheel-Trans. Attending care services provided by the courts for physical needs throughout and during the proceedings. An interpreter for those who are deaf. Laws which include the rights of people with disabilities, which actually are presently being advocated for, but they're not like in our written, specifically in our laws yet. Police and detectives, and this was really key for me because I had 2 male detectives come out and question me initially, and I felt very, very awkward because I'd just been assaulted 2 months before by a male, and I didn't really want to tell all the intimate details to 2 male officers. And also giving them some basic training around disability and stereotypes and the myths around disability related to violence against women. And lastly, I would just recommend that there be some resources in different formats, audio, visual, and tape, that prepare women with disabilities for an actual preliminary trial and trial within the courts. I believe that this would prepare the woman for what she may encounter during the proceedings. Thank you very much.
Navina Crisanti.
Thank you, and good afternoon to everyone. I'm very grateful to have been invited and to be here to hear all of this very important information, which I will take back with me, and hopefully that will be the first step towards making improvements. Although I'm very small in terms of the grand scheme, you've got to start somewhere. As you've heard, I've been an assistant Crown Attorney for a number of years, both on a part-time and a full-time basis, and before that I was in private practice, so I've seen both sides of the spectrum in terms of both defending persons with disabilities, which is another challenge, and also prosecuting offenses where the victim and or witnesses are disabled. But just to step back, I should let you know that I had the pleasure of meeting Fran Odette, who is seated to my left, some 30 years ago. It's funny how life takes its twists and turns and then comes full circle, because I was a counselor as a young teen at Sunnyview Day Camp for disabled children, and Fran was working there, and she was very important to we teenage girls who were receiving phone calls from time to time. And Fran was the conveyor of messages. She was wonderful, and she has not changed a bit in her bright determination and vigor, and it's very nice to see her again. But I also had the pleasure in that work in meeting the children and being exposed to their spirit and their delightful optimism and enthusiasm despite their physical challenges. It was a really wonderful, life-changing experience. So here I am 30 years later. What I'm going to do, though, today very briefly, and I'm cognizant of the time, is just a general overview of the criminal justice system, and then comment on ways that persons with disabilities can access services and perhaps be aware of the resources and maybe approaches that might improve what is an otherwise difficult, unfortunately difficult sort of process. So we'll start with the general overview. I should note that as an assistant Crown Attorney, I've prosecuted matters involving disabled victims, and I've observed the burden not only to all victims, but especially to disabled victims. And many of the speakers have touched upon why the victims, disabled victims, bear that burden. And it is shameful that to this day, some of those challenges still exist, but I am confident and determined to do what I can. But what I've been inspired by is their courage despite that. And it's what I call the courage of a lion, and I've not seen that courage anywhere else. So my credit goes out to each and every one of them as an example for all of us in the way that we're lacking. But the criminal justice system is a very formal process, and we'll go over basically what it involves in somewhat of a chronological fashion. But we can begin by saying that the laws that govern the ways in which criminal acts are investigated, prosecuted, and adjudicated are known collectively as criminal procedure. So it's a stage of where the complaint is made, it's then investigated, the matter may be prosecuted, and then a decision has to be made about the allegations. Crown attorneys are lawyers who act as agents of the Attorney General of Ontario and conduct prosecutions of persons charged with criminal offenses. So they're not the victim's lawyer. And since they're not the victim's lawyer, there is no solicitor-client privilege that attaches to communications between witnesses and victims and the Crown attorney. So that's not privileged. That's something that's important to bear in mind. Unlike the victim's own lawyer, in which the privilege attaches, and then you as a client are protected in terms of what will or will not be shared, what you've told your lawyer. There's a protection there that's very important. But that can't take place, or that can't occur between a victim and the Crown attorney, because the Crown attorney has an obligation to provide the accused with disclosure that will entitle the accused to make full answer and defense to the charge, because as you know, in Canada we have a presumption of innocence. So all criminal proceedings, though, are against the accused person in the name of the Queen, and it's somewhat confusing when you see the title of proceedings because they appear as R.V. and then the name of the accused, the surname. But for instance, a prosecution against a hypothetical John Smith would be referred to as Regina, hence the Queen abbreviated to R. period, versus Smith. So it's the prosecution in the name of the Queen against the person charged. A witness is a person who is likely to give material evidence. And a witness takes many forms in terms of the type of evidence they'll give. Some are eyewitnesses, although in many abuse cases, and in my experience, most sexual abuse cases, there are no witnesses except the victim themselves. The victim is defined in the Criminal Code of Canada as, quote, a person to whom harm was done or who suffered physical or emotional loss as a result of the commission of the offense. And we'll get into the victim impact statement and what that involves. And that is something that is dependent upon the definition of victim. Not anybody can supply that sort of a statement. So the process usually begins with a complaint to the police, so that as a victim, you can either make that complaint yourself or somebody can make it on your behalf. But eventually the police will want to interview the victim if possible. And this interview process is what's referred to as the victim's statement. And Gwen referred to the fact that she gave a statement. The victim's statement, in ordinary language, is the victim's account of the allegations of what happened. And the police must provide a copy of this statement to the Crown Attorney, and the Crown Attorney will provide a copy to the accused, so that as a victim, when you're contemplating what route you'll take and whether or not you'll provide a statement, it's important to know that what you tell the police, again, is not confidential and will be shared ultimately with the accused and probably with the court if the matter goes to trial. And if the matter does proceed to trial, the victim will be asked questions about that statement that they gave the police. The police investigate the complaint, and if they're satisfied that appropriate grounds exist to believe that the offense has been committed, then they'll lay a charge against the accused. The accused will then be brought to court for a bail hearing or be required to attend for the first appearance out of custody. That's one of the sort of mysterious areas, is what happens after a person is charged. Well, if they're arrested, then whether or not they remain at large with conditions attached or detained before the bail hearing is not known for certain. But if the accused is released on bail, then he or she must follow certain conditions, and they are designed to protect the victim of the offense. A typical condition will be that the accused is to have no communication directly or indirectly with the victim or perhaps any member of their family, and remain 500 meters away from their place of residence, employment, or education. The accused can decide whether or not to have a trial or plead guilty. If the accused enters a plea of guilty, the witness won't generally have to testify. And the accused is entitled to some mitigation for that. But if they plead not guilty, then the Crown must prove the offense beyond a reasonable doubt. Gwen spoke of the preliminary hearing. That's a stage in the process. In more serious matters, the accused can decide or opt to have a preliminary hearing and then go on to a judge alone or trial, or a trial with a judge and jury. The preliminary hearing is sort of the test case where the Crown must prove that there's enough evidence for the matter to go to trial. But it does involve, unfortunately, the victim testifying twice. So that if the matter goes to trial, the Crown will have to prove it, and the way they prove it is by calling witnesses, and one of the witnesses that is usually called is the victim. And when I say usually, in most cases, the victim is required to testify, so that when you lay that initial complaint, when you complain to the police about what's happened, you may think that after that you can decide that you don't want the procedure to continue, but unfortunately once you, or fortunately, I won't maybe express an opinion on that because it's debatable, but once you, the charges are laid, then you as the victim cannot determine whether or not the matter will proceed. You can't decide, I want this to stop now. It's something that perhaps you can discuss with the Crown for input, but you of your own right can't withdraw a charge. After a finding of guilt, if that has occurred, but before the sentence is imposed, the victim will have the opportunity to complete a victim impact statement to outline how the offense has affected them. And the judge must consider that before sentencing, and VWAP staff will normally help the victim with this statement. That is the general overview. Now we can move on to services for victims, and I'll just outline them briefly. And if you want more information about the services available to victims, you can access the website, the Ontario Victim Services Secretariat website. But I'll start with VICRS. VICRS is an acronym for Victim Crisis Assistance and Referral Service, and it's a community response program. It provides immediate on-site service to victims of crime or disaster 24 hours a day, 7 days a week. And police officers who are called to a scene of an emergency, if a sexual assault has occurred or a violent offense, they will call on VICRS volunteers to send a team of trained persons to provide on-site short-term assistance to victims and to make referrals to community agencies for longer-term assistance. There's also a program called Support Link that provides safety planning, which is important for many victims, and then follow-up contact where appropriate. And in some cases, wireless telephones pre-programmed to 911 to assist people in high-risk matters such as sexual assaults, domestic violence, and stalking. And that is something that is provided free of charge in certain cases. There are also sexual assault and rape crisis centers that operate 24 hours a day to provide crisis and support, including police and hospital accompaniment and counseling. The Victim Support Line, known as VSL, is a province-wide bilingual toll-free information line that allows callers to speak with an information counselor about supports and services. It's also an important service because it allows you to register to receive notification of release dates. So that, and this is for provincially sentenced offenders, so an offender who is sentenced to 2 years less a day. You can be notified when they'll be released, for instance. And you've also heard Gwen speak of VWAP, which is the Victim Witness Assistance Program of the Ministry of the Attorney General. And this program has been in place since the 1980s, and in my view, both as Crown Counsel and as counsel in my current position, where I'm counsel for the program, I can say that I highly endorse it. As a Crown, I relied on Victim Witness Assistance staff to be the buffer between myself and the victim. And you've heard Gwen talk about how it was difficult to access the Crown. That is an unfortunate reality. But do not underestimate the importance of the VWAP staff, because they are your link to the Crown. VWAP, I'll just go over the system basically, but after charges have been laid, VWAP services are available to you up until the disposition date. So basically, all throughout the process until the matter is dealt with, you will have the assistance of a VWAP staff member. And they will provide you with information about your case so that you're updated about the next court date, about bail conditions, for instance. They routinely send a copy of the bail condition, and they telephone you to let you know, so that if you have special needs, you can make arrangements with VWAP staff to have your needs accommodated. They also provide you with support throughout the process. So they'll go into court with you. They can be your support person if that's who you request. And they attempt to enhance your understanding of and participation in the criminal justice system. So if you can't access the Crown, then you can definitely access VWAP and let them know that you'd like an appointment with the Crown. And so that if you know of any victims that are in the process, you can ensure that they make that link as soon as possible. So VWAP also, in terms of services, helps with crisis intervention, needs assessment, referrals to community agencies, emotional support, case-specific information, the provision of it, and court preparation and orientation, so that with all witnesses, but especially in my view with witnesses that are also disabled, the court preparation and orientation in advance of their court attendance is very important. I should note as well that the Criminal Code in Section 486 outlines testimonial aids that are available to victims of crime to aid them while they're testifying. And I'll give an example. Where a witness has a mental or physical disability, the court may order that a support person of the witness's choice be permitted to be present and to be close to the witness while testifying. So as I said, VWAP staff are available to do so, but a disabled person could choose who they wanted to. Now this is at the discretion of the judge, the presiding judge, but the Crown can make an application for that. Now the issue is that the Crown needs to know that you would like that. VWAP staff will go over all of this with their clients, clients who generally are witnesses or victims. But further in Section 486, a witness who is under age 18 or is able to communicate evidence but may have some difficulty doing so by reason of a mental or physical disability, in those cases the court may order that the witness testify outside of the courtroom by way of closed-circuit television, or behind a screen, and I'll describe what is meant by a screen, or other device that would allow the witness not to see the accused. So if you can imagine the intimidating process itself of having to tell the story of something as grievous as a sexual assault or other forms of abuse, but then have to face the offender and the public while doing so. So to make that, to alleviate that intimidating process, to make it somewhat less stressful, you can discuss your fears, for instance, with VWAP, and VWAP staff can convey that to the Crown, and they will advocate on your behalf about the need for testimonial aids such as a screen. Now, what the screen allows is, and generally when I've dealt with cases where I've used a screen, we have the witness seated in the witness box or in another acceptable place. And we set up the screen before the accused and the public is brought into the courtroom, if possible. So that normally involves taking a break. The screen itself is placed in front of the witness. And the witness can see out of the screen, but only in shadows. So they don't have to see the offender or the public. But the offender, the judge, and all of the other persons with a vantage point can see the witness, because part of testifying is not just the verbal portion of testifying, but also the demeanor of the witness. And it's arguable that the accused and the trier of fact has the right and the need to observe the demeanor of the witness. So the screen provides for that. But I've actually heard of cases where inventive Crowns have not had a screen, but have not stopped there. They used, in fact, a ski mask that the victim felt comfortable wearing. The victim was a skier, and she was able to testify in that fashion. So when the criminal code says a screen or other device, in that case, the other device was a ski mask. So those are some of the accommodations that can be made. I should note that the same section also limits the right of the accused to personally cross-examine the victim in some cases, and that becomes relevant, for instance, where an accused does not have a lawyer. So you can imagine the possible trauma of you being a victim, or any of us being a victim, and having the perpetrator then cross-examine you on your statement. So to address that, the code does have this provision where the right of the accused to do so can be limited. The code also provides for a non-publication order of the name or anything that would identify the victim, so the court can order that. And in some cases, the court can order that the public be excluded from the courtroom. Now, that's not an easy sort of application to convince the court of, because it's a public forum and the public has the right to observe the proceedings, but certainly it's something to contemplate. So what advice can I give to victims or advocates on their behalf in terms of the criminal justice procedure? And I of course can't cover everything, but with your help I can make the list more fulsome. But just the following I ask you to keep in mind. The first point of contact will be the officer in charge in most cases. The officer in charge is that officer that has carriage of your matter. So what I suggest is that you advise them that you would like to meet with the Crown Attorney and or VWAP staff as soon as possible, or make arrangements to call the VWAP office or the Crown yourself. If you can't get to the Crown because they are prosecuting matters in court all day, so they don't have that leeway, then you can certainly get to the VWAP staff more readily and let them know that you want to meet in advance. Crowns are encouraged to meet witnesses of serious matters in advance wherever resources permit them to do so. So in my experience, they will be and usually are as helpful as they can be. But if at first you don't succeed, do not give up until you at the very least speak to the VWAP staff and convey concerns. Secondly, discuss your physical needs in advance of the court appearance. I shudder to think of a situation where a victim would only on the date of the trial have to address issues such as this. As the Crown, I put myself in the shoes of victims, or in dealing with children, I put myself in the shoes of the parents, and I'm not sure how pleasant I would be as a parent if my child had no contact whatsoever before testifying, especially before a jury. So just do what you can to meet in advance. Now, additionally, arrangements can be made for the use of a bliss board interpreters, sign language interpreters. I've dealt with cases where we've used that, and amplification systems, and Braille transcription systems. But these sort of arrangements take time, so again, I stress that it's important that you meet in advance, or someone on your behalf. Gwen referred to the difficulty she had in accessing the witness box itself. I'm very sorry to hear that. That is something I'm going to be taking back to the office. But I do have a point. Before I even heard that, my point is arrangements can be made to address your fears about physically accessing the courtroom itself. VWAP staff will be able to assist you in conducting a tour of the courtroom. And I was involved in that sort of court orientation as the Crown because I felt that of all the stress involved in testifying, the one that you don't need is trying to understand and figure out where you're to walk when you enter the courtroom, where you're to stand or where you're to stay seated. Just those little details you really can alleviate with that court orientation. You can do that in advance of your court appearance, and that's a great trial run. Most courthouses, in my view, all courthouses should allow for chair access. Many courtrooms, in addition, can be accessed through separate private witness rooms. So in that court orientation process, you can discuss these issues with the Crown, for instance, or advocates on behalf of victims can do so. Certainly VWAP is there to help you, but if I've dealt with a case, for instance, where the victim is terrified, particularly terrified, or there are access issues, we can set them up in this witness room, and they will be able to enter the courtroom in some locations through a different door and not have to deal with the public. So accommodations can be made. Finally, the VWAP offices are structured such that they provide a secure environment for witnesses in terms of a waiting room. You can access the room in most locations only through a coded entrance, so the public won't be allowed. So you've always got that option. You don't have to just wait in the hall room. But discuss your safety concerns, canvass the testimonial aids listed, as I've indicated, with the Crown and VWAP staff and the police. And above all, communicate as early as possible. Thank you very much.
Thank you to all our speakers for very informative presentations. I've decided to stand here because we don't have a microphone at the end, and I think it will be easier to do the discussion if I leave the microphones for the speakers. We now have approximately 20 minutes for a question period or a discussion. We have microphones, and I would encourage those who ask questions to ask them with a microphone. We do have someone to move the microphones around. And we also have Teresa, who is here to offer assistance if required. So are there any questions from the floor? We have a question at the back. Could I ask you to repeat your question? I apologize. I was trying to find someone who can move the microphones around.
It's my understanding that if you are victimized and you try to pursue things with the police and the Crown decline to or feel that there's not a basis for going forward with the case, that you do have a recourse of going to the Justice of Peace. Is that another option that people would have?
Yes, you're correct in saying that. But I do caution those that are contemplating that process that it is an intimidating process, because in most jurisdictions the complainant would have to become involved in what's called a pre-enquête hearing. And by the terminology you can tell it's a formalized process. And in the pre-enquête hearing, before the charge is even laid, basically, the victim will be asked a series of questions to satisfy the justice that there is sufficient evidence to go forward with the charge. So yes, that is an option, but wherever possible, in my opinion, the complainant should speak to a lawyer first. And in many of those instances, VWAP can assist as well. Okay? So that's the note of caution.
We have another question at the back. I don't know if it's possible for you to come to the front. No. Okay, I will repeat your question then. The question was, we know that persons with disabilities sometimes need longer time to communicate with their lawyers and need longer time for transportation. And is it possible to extend hours on legal aid certificates?
Lawyers and legal aid generally have a duty to accommodate persons with disabilities. And so what's important is that the person, when they're applying for legal aid, whether it be a legal aid certificate or for services from a clinic, that it be clearly stated what sorts of accommodations they need, whether it be extra time or something else, and ask that those accommodations be granted. And that's the same for lawyers in private practice who are not being funded by legal aid. It is also their duty to accommodate clients with disabilities. But what's very important is to make your request clear about what accommodations you require.
Thank you. Another question from the floor? I do have a question for the speakers. I was listening to you, and especially Lana, you mentioned the number of possible or potential recourses in the justice system. And I'm wondering if you could give us ideas on where you would go if there is an issue of abuse and you want to access the legal system. Do you have to go to a lawyer? What are the cost implications of going to a lawyer? And what are the resources available?
There isn't one single place where a person who's experienced abuse can go for assistance with all of the various avenues that they may wish to pursue. And not all of them would require the assistance of a lawyer. And so, for example, if an individual wanted compensation through the Criminal Injuries Compensation Board, or wanted to file a complaint with the Human Rights Commission, or wanted to complain to the government or a service provider about attendance services, they would be able to do that on their own. On the other hand, there are other processes which are more formal, such as civil suits, where it's much, much more difficult to pursue without legal assistance. Having said that, it's better to have legal advice if an individual has experienced abuse, because the lawyer would be able to canvass the range of options and interactions between them and help the person who's experienced abuse to weigh the different options and make a decision about which to pursue. And there is a possibility to get a legal aid certificate or to get assistance from a legal aid clinic for that. And the phone number for Legal Aid Ontario is in the fact sheets. But remember that legal aid only funds people who meet their financial criteria and only assists people with certain kinds of matters, although people could hire lawyers independently through the private bar. And one final thing to mention is that if an individual who has experienced abuse wants to pursue legal options and does not have legal services available to them, there are lots, well, maybe not lots, but there certainly do exist publicly information for the general public on laws relating to abuse, and so that it would be a good idea to seek out that information. There are Community Legal Education Ontario produces pamphlets in plain English on Criminal Injuries Compensation Board, on home care complaints. There are the fact sheets in the binder today, so seek out and make use of whatever information does exist.
Thank you. I think we have a question here.
I actually have so many questions, but I won't ask them all today. I work in the field of education and abuse issues, and have become more directly involved in the issues of abuse and people with cognitive disabilities. And there's a huge issue that we're facing, and that is, it's on a number of fronts, and one is about reporting and about agencies reporting abuse, and the other is any case going anywhere, even from the very first step of police and charges being laid to getting to court is nearly impossible because the person is not seen as a credible witness. And I think to myself, I don't think we can get people to change to the system. Do you think the system will ever change to adapt to people, just as the system changed sort of to adapt to children over the past number of years and put things into place? Will the system, do you think, change for people with cognitive disabilities, so that the whole issue around what's deemed as a credible statement and testimony differs or adapts to that? But a big one is around also the responding and reporting abuse. Yeah. I know in Alberta they have set up an act that demands that people report abuse, and it's investigated.
I can understand your concern. As a Crown, I've had to deal with cases that were extremely difficult. They're tough decisions to make, and what I've observed is that vulnerable victims, vulnerable persons, are almost targeted by offenders because they will not make potentially easy witnesses. So it's a vicious circle. One of the last cases I prosecuted before this secondment involved a developmentally delayed young adult who functioned at the level of about a 6-year-old. But we were able to manage, although it was very difficult, because in my view we had a very determined team, starting with the police. But I think that I think there is hope. I think the answer is education and awareness. There are resources available to Crowns when dealing with cases such as these. One is calling an expert witness. Now, ultimately, the decision will be up to the judge. So, in my view, what we need is a collaborative approach to education. So that would be with care providers, with police officers, Crown attorneys, and judges. That's our only hope. But this sort of forum is what brings these issues to the surface. I can tell you, though, that judges are necessarily independent, so that in terms of education, a suggestion from me won't necessarily matter because they decide their own education. And I don't know what their education includes in that regard, but I think education is the answer. I have convened 2 conferences. They're annual conferences at the Ontario Victim Services Secretariat. The past 2 years, we've included a segment on Crown training. We've included a segment on the issues surrounding prosecuting matters where the victim is developmentally or physically delayed. So I know that we reach out to about 100 Crowns a year in that regard. But one of the points that I will take back with me to bring to the attention of the Ontario Crown Attorneys Association at the very least is education in this area.
Would other speakers like to comment on this?
I just wanted to mention very quickly that I think education is key, but I think that also that I think more people that do come forward will have to force the system to deal with it. And I think that's the only way that we're really going to see change is when people can have the supports, have the advocates to be behind them to be able to go forward, because the system will then have to respond.
Thank you.
Good evening. I'm wondering, in light of the recent passage of Bill 118, and thus the new law that we have in Ontario, what leadership role the Law Society, in its privileged position, will be taking, and what plan of action you have in order to demonstrate the commitment that you have to segments in society that have gathered in the room. And it would be interesting to know, the response of the other groups that have gathered in light of this interesting and hopeful development.
Do you want to expand for the audience what you mean by Bill 118?
I'm sure people in the room know I don't want to be pejorative. The new Ontarians with Disabilities Act, the short term, the ODA, the new ODA, that was just passed into law in the past month after first, second, and third reading. I imagine everyone in the room has put their 2 cents in for it. That's been worked on over years and years. So I don't know what I could do. I'm sure everyone knows more than me on it, so, or as much, or if I've worked on it at different levels and different stages. I'm sure everybody has, so people wouldn't be here if they weren't involved with it, likely, so.
I can tell you that from the Law Society's perspective, we have a number of programs in place that deal with...
No, I just mean how you're now going to adjust your programs in light of this new law, which is mandating action now on your behalf.
Well, we have a number of programs in place that we will be working on. We have undertaken a consultation with members and lawyers with disabilities, and we will be coming forward with a report on that. And
when will that be?
The report will probably be made public in the fall.
And will David Lepofsky be writing it, or will you be writing it?
No, we've hired a consulting agency to do interviews with members of the legal profession and...
who have disabilities self-identified, or...?
No, it's a consulting firm that we've hired, Strategic Counsel, to do interviews with members and students with disabilities.
So Alan McEachern, then?
Pardon me?
Alan McEachern is then doing it?
No, the Strategic Counsel is doing the interviews.
Alan McEachern.
Well, Hugh Anderson is the main consultant on the project. However, what we've done is we've set up through our Equity and Aboriginal Issues Committee a disability working group, which includes a cross-section of members of the legal profession. And they are there to advise and to direct the research project. And so they will be looking at the report provided by the consultants and then in turn make proposals to our Equity and Aboriginal Issues Committee, which is our standing committee of convocation on equity and Aboriginal issues.
I guess I didn't phrase my question very clearly. I'm wondering how, in light of all this, which we're so pleased that the Law Society has this, and of course we're all familiar with that naturally, so we're wondering how that committee is now going to respond to Bill 118, the new ODA.
I can ask the chair of the working group, who is standing right behind you, Tom Heinzman, to answer.
Hi, I'm Tom Heinzman, and I am the co-chair of that committee. That committee is looking into matters largely from the context of lawyers with disabilities. And so that's a good starting point. So we have on the committee many individuals who have disabilities and a wide-ranging nature of disabilities. And I would like very much, and I was going to ask this question to the assembled group, as to how can we get the input of the disability community to the Law Society, and what are the issues that lawyers as lawyers, not just disabled lawyers, but lawyers as lawyers can do to address the issues that we've been talking about today. And I think this is one of the objects of this exercise, is to ensure that we just don't talk about disabilities, but we do something about them as lawyers. Here we are in the Law Society, so I would be very anxious to hear from the panel. Certainly we have a committee that's more than motivated, going to do something about this. I mean, obviously the Law Society has to address it as a organization. You know, what do we do with this building? What do we do with the way we operate to address issues of disability? Second stage is what do we do for lawyers with disabilities? But the third stage, which is what for them, with them, and what do we do for the disability community, which is interfacing with lawyers who are there to help them. And that's where I would like to hear any views today as to how we can keep that dialogue going and starting.
Wonderful. Thank you.
Any of the speakers want to comment on that?
Do you want me to? I could say something briefly. My name is Gwen Reed, and I work with Fran Odette through Education Life Results. And some of the workshops that we provide, actually all of them that we provide to other agencies and service providers, try to outline some of the stereotypes and myths of people with disabilities and try to debunk those myths. And I think the more workshops that we do and the more partnerships that are created, the further things will go. Just as an example, we have just gained funding so that we now in 2 shelters within Toronto have attendant care services available to women with disabilities who want to access these shelters. And I think that's a major accomplishment. And when I first started out with the project, I worked as a peer supporter, and then I moved into the accessing and education side of it. And I see it as 2 different agendas, but they're similar in the fact that they educate the women with disabilities that they provide service to and their service providers, and also the organizations that are involved. So I think it's a continual process, and with talks like these and organizations working together, I think it's a great beginning point. Thank you.
Thank you. We have a question at the front.
Thank you. A comment and a question, actually. In regards to the work the Law Society is doing, I think this is good to hear. In terms of the question about finding representatives of the disabled community and advocacy groups. I submit that's not so hard to do. And I would have expected that when you were selecting the consultant to do your project, that some considerable knowledge of disability issues and disability community would have been a required requisite in your tendering process. Certainly, my organization, the Alliance for Equality of Blind Canadians, we're one of many organizations that undoubtedly has views on the state of the legal profession. But my question goes to something else, and that is for disabled people who want to get into the profession. And you might be able to help me on a question here, because I've recently received an inquiry from a blind woman in the United States. The LSAT process in the United States has been a problem, and there's been a number of bits of litigation going on. Specifically, where test takers use alternate formats, their test results have sometimes been starred and have not been sometimes taken account of with the same force as if they hadn't used the alternate formats that I believe they're entitled to. I'm just curious as to what the practice is in Canada, because I honestly don't know, and if you could enlighten me or give me someone I could contact, that would be most helpful. Thanks.
We can probably give you contact information for the LSAT office. The Law Society does not coordinate testing for the LSAT office. As far as entrance into the legal profession, from the Law Society's perspective, we do have an education support service that provides accommodations for the students who are going through the Bar Admissions Course program.
I have a question here for Navina. I wondered if there are any protections afforded to people who are afflicted with psychiatric disability, who are defendants in criminal proceedings. I was thinking of a case in point where the accused is recognized under the Ontario Disability Support Program and has been at all material times over the last 6.5 years in a proceeding where the Crown is prosecuting.
I'm not sure I understand the question. The proceedings have been in place for 6 years?
6.5.
6.5, sorry.
The accused has been appearing for 6.5 years, and at all material times has been under ODSP. Are there any protections that could be extended to that person, or that person could raise in defending the court proceedings?
That is a very difficult question to answer without an understanding of the allegations and the circumstances. Any case that's been in the system for 6.5 years, in my view, is a fairly unusual circumstance in and of itself. There are sections in the code that deal with the fitness of an accused, or in terms of the accused's ability to answer to a charge, but those are protected by a process in which a psychiatric assessment is conducted by a doctor outside of the court proceedings, and then a decision is made by the judge. So I don't think, in fairness, I can answer your question without a knowledge of more of the details. I'd be happy to try to assist you after this panel has recessed, but I would have to know more information. And in fairness, my perspective today is as a Crown, and then in my current position as Victims' Counsel.
I'm sorry, I thought you had mentioned that in private practice you had defended people with disabilities.
I had many years ago, but I am happy to speak to you further about it, but I would need to know the facts.
Thank you.
Okay, sir.
We have time for maybe 1 or 2 more questions. Okay. So I think what you're saying is, in answer to the question of what the Law Society could do, is to have available sensitivity training for lawyers. Mandatory in bar ads might be a good idea. So I'm just repeating so that everybody will hear, so let me know if I'm not repeating properly. So on disability, in addition to Aboriginal equality seeking types of training, there is right now a section on so what we're saying is it has to be mandatory. The training we have in the bar admissions course right now on servicing clients with disabilities is not mandatory. And that is the problem. So the suggestion is that a panel such as the one we had today would be extremely instructive for lawyers, especially considering that we have here the perspective of lawyers and consumers, and that would be a good addition to the training we do with lawyers. That would be perfect, especially at bar ads. We're saying that mandatory training with police officers in this area would be extremely helpful. I have 2 hands up, I think. 3 hands up. Okay, we'll start here. So the question, I believe, is do workers in VWAC get special training, especially on disability issues, but also on intersectionality issues such as race, gender, etc., in addition to other types of training they get?
And I guess the last part of the question was whether or not there were experts. I can speak to the fact that VWAP staff does receive specialized training, and certainly it involves dealing with clients with special needs, including physically and developmentally delayed clients. There are no experts, though, to my knowledge. It's general training. It's something that we're currently expanding, though. And as I mentioned earlier at our annual Crown Training Conference, for the past 2 years that I've been conducting, or at least organizing the training, we've included a segment on dealing with victims and witnesses with disabilities. And that has been for Crown attorneys, police officers, and there are VWAP staff there as well. So that is in the works. Forums such as this bring to the surface the enhanced need to supplement that training, to increase it, to improve it. So I'll be going back with that.
I will take it. There was one question here, and then there was another question back there. And then we will have to close, I think. Thank you. So I'll repeat briefly that mandatory training is a wonderful idea for police and lawyers and service providers, but there has to be expectations and benchmarks, and that kind of training has to be offered throughout the province and not only in large centers, urban centers. I'll take one last question, if there is one. Yes. I missed the beginning of your question, but I think the question is whether or not the police forces were notified of this event today. We broadly advertised this event through our own website, but also through our contact list and through Arch's contact lists. And the information session was advertised through the Toronto Star. So I think the information was out there. I can't add more, except for saying that our communications expert is here.
I just wanted to add to Jose's response. I'm Rudy from the Law Society. We did get an RSVP from the police, the Toronto Police Service. Unfortunately, those who did RSVP are not here with us today, and so they did respond, they did get the promotion, and they were very interested in coming to this event.
Would you mind repeating the question while answering briefly?
Repeating the question. Sorry?
Yes, we don't have a microphone.
I'm not in a position
so.
to answer that on behalf of the Attorney General's office. I'm sorry.
Okay, thank you. The question was, given that the police is the first point of contact, I guess you wanted to know what the Attorney General's office view is of having a police force that is male-dominated and not here today. So I would like, it's 6:05, so we've gone over our time period for this workshop. I wanted to thank our panelists, and I believe Phyllis Gordon will give you a little gift as a token of our appreciation. So I will leave the microphone to her. Yeah.
You know, people who know me will know how frustrating it has been for me not to be here to participate in answering some of the questions. And so I won't answer all of them, but I am going to say something about who's here and who's not here, because I think it's really important that we look at what's happened. We have a fabulous turnout from the community and people who work with disability and with people with disabilities. We have a less than fabulous turnout from the Law Society. We have leadership from the Law Society here, of which we are very grateful. We don't have many lawyers here today, and this was well advertised in the legal community. So I do think that we're going to do our best to report the kind of numbers and the interest that you people have brought, and bring that word back to the Law Society and take on some of the training and the interest issues. Arch has been involved in training for a long time of lawyers around issues with people representing people with disability, And one of our projects currently, hopefully with the Law Society, or with the Law Society, we're not sure exactly when it'll happen, we will be publishing an article for the profession and for police about all the different legal avenues that relate to abuse. It will be much more detailed than the fact sheets. So that's a work in progress right now, and one of the things that we'll be letting people know about. But I do have to reiterate, I would have loved to see 20 lawyer hands go up as well, but I'm more than happy that you people are here, and thank you so much for coming. May I just, I think we'd better, yeah. Yeah. Very good. Lawyers Weekly is here. That's incredibly important. Thank you. Goes to all the lawyers in the province, so, you know, give us a good spread. And I want to sincerely thank all the people on the panel who have put in a lot of time thinking about the issues, and, you know, I think we've done really well by you people coming and talking to us. Thanks so much.
Thank you very much. We will take a break, and then we will reconvene here for a reception. You all have the evaluation forms in your materials. If you would like us to email you evaluations form, let us know. And we also have assistants to assist you in filling out the evaluations form if required. And enjoy the reception.
Yeah, there's one that you should have bought. Yeah, you should have bought it.
BWAP. BWAP.